now put.
I'll hear from Chris Hipkins.
Thank you very much, Mr Chair. I'm very happy to take a call on Part 2 of the Legal Services Bill. The points that I want to raise relate primarily to coverage of the legal aid system, and particularly Clause 7 of Part 2, which relates to proceedings for which legal aid may be granted in the case of civil matters. And one of the issues that I want to raise with regard to this bill, with regard to what I believe is a growing inequity in the system, is that ACC cases are not covered by the legal aid system, according to the clauses in this bill, up until the point they reach the district court. And what we're seeing within the ACC system is a dramatic increase in the number of ACC cases that are being declined, therefore a dramatic increase in the number of cases that are going to review, to disputes review. When they go to disputes review, I think the amount of legal assistance available is limited to something like $700 or $800 for an ACC disputes review if somebody has been rejected, their ACC claim has been rejected, probably significantly less than what they would get if they were entitled to legal aid for that particular process. And what we're seeing in the ACC disputes process is that ACC certainly have access to a lot of highly paid, high-quality legal assistance, but those who are seeking review, who are seeking some redress, they believe they've been treated unfairly, they don't have that same access to legal support. And so the question that I have is, if ACC is going to become a much more litigious system, which seems to be happening under the tenure of this national government, why shouldn't somebody taking legal proceedings or taking a review proceeding through ACC be able to obtain legal counsel and legal assistance? This is a very real issue. The number of surgery claims, for example, for ACC that were rejected doubled between 2008 and 2009. So in other words, under the national government, the number of ACC people who have been applying for elective surgery through ACC, the number of them who have been turned down has doubled. What's that resulted in? The number of reviews. In other words, the number of people who have been saying, I want my case reviewed, I've been rejected by ACC, I want to go to the ACC's disputes resolution service, that's almost doubled also during the tenure of the national government. And the number of decisions being overturned through that process has increased by about 400. So what we're seeing from ACC is that their more instant reaction quite often is to decline a case on the basis that someone can then take a review. They're basically pushing people down a much more legal route in order to get their ACC entitlement. What that means, and for this bill, in relation to our coverage of the legal aid system, is if the government are going to take a much stricter approach for ACC claimants, why shouldn't those claimants actually be able to get quality information and quality advice on their entitlements? Because everybody pays into the ACC scheme, everybody gives up something in order to be covered by ACC. What do they give up? They give up their ability to sue in the case of accidents. They can't sue in the case of accidents. And what we're seeing is that ACC are basically clamping down. They're not giving people the things that they are entitled to under the scheme. And in that case, if people aren't getting what they're entitled to, why shouldn't they be able to get legal advice to actually make sure that their entitlements are being upheld? They're paying for it, and they're giving up their right under the common law to sue in order to be part of the ACC scheme. So I actually think there's a legitimate question now with the increasing number of complaints about ACC, the increasing number of reviews, a legitimate question to be asked about whether or not legal aid should be extended to those people. I want to move on next to talk about proceedings before the Tenancy Tribunal, which are covered under this Legal Services Bill, and I think that's incredibly important. Because one of the issues that we're seeing with state housing under the tenure of the national government is that they are basically moving away from being a housing provider of last resort to one where they will use legal processes available to them in order to evict tenants. In my own electorate, we've got an example at the moment where Housing New Zealand are using a 90-day eviction notice to remove some people from the neighbourhood of Pomari because they can't actually make a case before the Tenancy Tribunal to remove them. So they're basically using the 90-day notice period, which can't be appealed through the tenancy tribunal, to evict people. But that's a small example of where we're seeing housing corporation using many more legal proceedings against housing, Mr. Chair. Thank you, Mr. Chair. Against Housing New Zealand tenants, and therefore I think it's really important that they have the full access to tenancy tribunal services, because I don't believe that Housing New Zealand is upholding its part of the bargain with regard to providing quality tenancies for State House tenants. They're not living up to the maintenance criteria, for example, that they should do, and tenants therefore should be able to take relevant action where they need to do so. So those are the points I had with regard to coverage. I also want to pick up the points raised earlier with regard to whether or not, with regard to the financial criteria that are used to determine whether somebody is eligible for legal aid, and the asset tests that they are subjected to there. I totally agree that in the case where the principle behind this should be that somebody, in order to for a certain asset to be considered under the financial test, the person has to have a reasonable access to that resource. The principle behind it is that the state should not be providing legal assistance to somebody who has the financial means to provide it for themselves. If that is the principle, I fail to see how Māori land that's shared and that cannot be disposed of can possibly come within that financial test. Because it's not like the person who is potentially going to be declined legal aid could turn around and say, I need money for a lawyer, therefore I'm going to hock it off. It's simply not, they simply couldn't do it. And therefore, to allow for the situation where someone could be denied legal aid because of some interest in Māori land which they cannot sell and they cannot dispose of, it simply means that they're going to be declined legal aid when otherwise they would get it, and that's an unjust outcome and it's blatantly unfair. And I'm looking forward to the contributions from the Māori Party, from the co-leader of the Māori Party, Tariana Turia, who's been conferring, I think, with the Associate Minister of Māori Affairs about it for the last 10 minutes or so. I'm assuming that they're working out what they're going to do about it, and that in a few moments one of them is going to stand up and tell us what they're going to do about it, because it's blatantly unfair. And I think if the Māori Party are actually going to claim to be the representatives of Māori interests in this Parliament, which I don't believe they are, then actually I think this is something that they should have a view on. I look forward. Hone Harawira might well come down to the House later on and have a go on it. I'd quite like to hear what he has to say on that, and I think he may well take a call on that. I'd like to hear what Simon Bridges has to say on that matter. I'd like to hear what Paul Quinn has to say on that matter. I wouldn't even go that far. I'd quite like to hear whether Paul Quinn has a view on whether or not Māori land should be taken into account when somebody is being denied access to legal aid.
It's part of the definition of disposable assets.
It's part of the definition of disposable capital. And I think that Paul Quinn should have a view on that.
Well, why is it?
It has to be. That's exactly the point. That's exactly the point. Paul Quinn says, because for those people who are listening at home or watching on TV, Paul Quinn says it has to be disposable to be disposable. That's what he's been yelling at us, and yet the bill doesn't actually cover that. The bill as being passed means that it will be considered. It will be considered. I think Simon Bridges should actually go and have a chat to Paul Quinn. I think he should have a chat to Paul Quinn and stop him making a bit of a fool of himself and read it slowly to him, and perhaps then he might...
I'm not the fool in this, so can't use the word you.
Thank you very much, Mr. Chair. Mr. Chair, I'm actually just coming to the end of my contribution. I think I've made with 1 minute 15 to go. So, Mr. Chair, by and large, with regard to Clause 2 of this bill, I think that it tidies up access to legal aid. I think that's really important. I think particularly in the current context where people are out there battling away and struggling to find money for the basics, I think it's really important that where they're going to find themselves involved in any kind of legal proceeding, that they should have financial assistance to do so. If they can't afford to pay the power bill and they can't afford to put food on the table for their families, which increasing numbers of New Zealanders are finding under the national government, they're certainly not going to be able to find money to fund a legal proceeding. So making sure that we have a legal aid system that provides for those people is very important. And this bill tidies up the legal aid system, I think, and addresses many of those concerns.
Chris Main.
Mr Chair,